Hope everybody's doing good. I said I would be putting more posts out and stuff like that, and I thought that this was something that would be good to share with everybody out there in the public. So the title of this broadcast is How I Beat a Multi-Traffic Case Using Constitutional Law. The $7 million lobbying secret that I have uncovered in the state of Ohio. It's definitely bigger than $7 million in the United States nationwide, but at least in the state of Ohio, the minimum that I've come to find through government documentation, through the Freedom of Information Act requests that I sent out and subpoenas. Now, in the United States, in 2025, on opensecrets.org for federal lobbying for the insurance industry alone was $172,196,074. The number of clients was 179, and the number of lobbyists, percentage of former government employees, was 924, which is a percentage rate of 57.58%. Basically, 60% of the people out of 924 lobbyists for the insurance industry were former government employees. That's pretty extreme when you look at that. And you can go on opensecrets.org and you can see all this stuff. opensecrets.org, it has all kinds of lobbying information. It breaks it down into all the different clients, parent companies, the total amount of money that each one of those client parent companies has donated, or not donated, but basically spent on lobbying to the federal government and state governments. But we're going to focus on the state that I live in, and that state is Ohio. What if I told you that traffic ticket in your hand isn't really about public safety? It's about forcing you to buy private company products. Now, this is a script that I built to make things uniformly. What if I told you that insurance companies spent over $7 million lobbying Ohio legislators to create the exact laws you're being prosecuted under right now? And what if I told you that I just beat multiple traffic cases in 2 different counties by exposing this entire system in court, and all my cases were dismissed with prejudice, meaning they can never be brought against me again? My name is Cameron Robinson. I'm not a lawyer, and over the past few months, I have gone from facing multiple traffic charges to achieving something that rarely happens, getting multiple courts across different jurisdictions to dismiss cases with prejudice based on constitutional violations. This is a story of how I did it and how the legal arguments I used might help you too. Now, a little background on me. Now I was actually in law enforcement. I was a correctional officer for about a year. I took the paralegals course, and I also took a private investigation course. I left the public correctional institutions, being an officer, because of just the inhumane treatment that I saw, just the constitutional violations of what I saw, and I wasn't going to stand for it, so I left it and I went into private security, and I learned the law myself. I've been pro se, reading the law the last 11 years. I've represented myself at least 10 to 11 times in court, pro se, by myself. And I'm sharing my story. I have law books and stuff that I have bought. I've got quite a few law books, but the most important law book that I'm going to share with you that all of you should buy is this right here, The History of the Common Law, the Development of Anglo-American Legal Institutions. It's by John Langbing from Yale University, Renee Leto Lerner from George Washington University, and Bruce P. Smith from the University of Illinois. Basically, this book is exploring the historical origins and development of the Anglo-American legal system. This unique new text covers trial by jury, civil and criminal procedure, bench and bar, law and equity, legal education, and legal literature, and the emergence of the modern legal profession. Vividly written, authoritative, and remarkably engaging, History of the Common Law boasts more than 250 illustrations, many in color as well as a wealth of historical sources that bring history to life in the classroom. This is probably one of the best law books I own, for the simple fact that it breaks down the fundamentals, the basis of where the common law legal system originated from. Like I said, I live in the United States of America in the state of Ohio, and the United States of America is a common law country. Now, to begin with the script that I have, that I've put down just to make it more organized for everybody to hear, my story begins. It started like it does for thousands of Ohioans every year. I got pulled over, I got ticketed, but here's the thing that made me angry enough to fight back. I had valid insurance the entire time. I maintained continuous insurance coverage. I wasn't endangering anyone. I had satisfied the exact government purpose these laws claim to serve: financial responsibility in case of an accident. But I was prosecuted anyway. That's when I knew something was wrong. If the stated purpose of these laws is to ensure drivers can pay for damages they cause, and I already had insurance proving I could do exactly that, then why was I being prosecuted? I thought it was just crazy. I was like, I already have it, and I'm not going to hire a lawyer because, like I said, I've been studying the law a long time. I went to school for it, and I've been to court many times to represent myself and have done my own negotiations. I was like, no, I'm not doing this. I'm doing this myself. That question led me down a rabbit hole that exposed a multi-million-dollar lobbying scheme and gave me the constitutional arguments that would eventually win my cases. I faced charges in 2 counties. Athens County had 2 traffic cases against me, and Meigs County had 1. In total, 3 active cases, plus 1 that had been dismissed without prejudice that I appealed. Over the next several months, I would represent myself, research constitutional law, and compile evidence of insurance lobbying from the insurance industry, file motions, argue before judges, and ultimately achieve what most defendants never do: dismissal with prejudice. But I'm getting ahead of myself. Let me show you what I discovered. The $7 million discovery. I started researching Ohio's mandatory insurance laws. Who wrote them? Who benefited from them? And that's when I found it. I went through public records from the Joint Legislative Ethics Committee. The JLEC reports tracking lobbying in Ohio. What I found was shocking. Between 2018 and 2025, the insurance industry coordinated a massive lobbying campaign targeting Ohio driver's license suspension laws and insurance enforcement mechanisms. Here are the numbers. Senate Bill 37, the Comprehensive Driver's License Suspension in financial responsibility law had 18 entity quarters of coordinated lobbying. That means Ohio Insurance Institute, 6 consecutive quarters of lobbying. AAA Club Alliance, 3 quarters. AAA Club East Central, 3 quarters. AAA Midstate, 3 quarters. AAA Shelby County, 3 quarters. 4 separate AAA entities lobbying the exact same bill in the exact same time periods. That's not independent advocacy, that's coordination. But it gets worse. These same entities lobbied at least 9 different bills, creating and expanding insurance enforcement. Senate Bill 152, enhanced penalties for not having insurance. House Bill 336, reinstatement fee amnesty that actually maintains the fee system. House Bill 158, limited driving privileges for indigent people, acknowledging the system creates unconstitutional barriers while keeping the core structure. Isn't that crazy? They acknowledge the unconstitutional barrier they create for people who are indigenous, which basically means people who are poor, people who are poor. They themselves in House Bill 158 acknowledge the system creates unconstitutional barriers while keeping the core structure of what is a part of why people are kept poor. House Bill 106, probationary licenses for young drivers. House Bill 283, distracted driving as a new primary offense. Each bill on the previous one is built on the previous one, creating layers of enforcement mechanisms that all lead to one thing: forcing you to buy insurance company products or lose your driving privileges. Now here's where it gets truly outrageous. The insurance industry reported spending only $4,666 over 7 years in their JLEC filings, Joint Legislative Ethics Committee filings. That means in 7 years, all the different insurance lobbying companies reported only spending $4,666 to the Joint Legislative Ethics Committee of the state of Ohio, which is impossible. But according to an investigation by me, the actual spending was over $7 million. That's a 1,500 times discrepancy, 1,500 times. They're underreporting their actual, think of that, they're underreporting their actual Joint Legislative Ethics Committee lobbying financial filings by 1,500 times. Because the minimum that I found was $7 million, and I'm going to show you why. Major insurance companies like Nationwide and Progressive reported 0 bills and 0 expenditures for 30 consecutive quarters while employing multiple lobbyists. State Farm reported only $18.38 over 7 years while employing 3 to 4 lobbyists continuously. When I found this, I knew I'd found something powerful. I knew that when I found that, I was like, the jury is going to flip. The jury of the people are going to flip when they hear the absolute fraud that's going on, that's being perpetrated on the state of Ohio taxpayers by the insurance industry in the state of Ohio. Now, this goes on. This is not just the state of Ohio. This goes on nationwide in all the states. But I live in Ohio, and this is my investigative reporting on what I have found in the state of Ohio. Through government documentation, through the Freedom of Information Act, and subpoenas to government agencies to get this information. This isn't just stuff I pulled out of my behind. This is actual government documents you can look at yourself. The constitutional framework, as I dug deeper into legal research, I realized these facts fit perfectly into established Supreme Court precedent that prohibited exactly this kind of government action that was going on. Let me break down the constitutional violations I identified. Number 1, Marshall versus Jerrico and Tumey versus Ohio. These Supreme Court cases establish that government cannot use its coercive power to benefit private parties with a financial interest in the enforcement outcomes. When insurance companies spend $7 million on average in the state of Ohio lobbying for laws that require citizens to buy their products, and then government enforces those laws by taking away driving privileges and applying fines, that's government serving private profit, which the Constitution prohibits, which we already have constitutional Supreme Court cases in Ohio and in the federal government, like I just said, Marshall versus Jerrico and Tumey versus Ohio, that explain exactly why this is unconstitutional, what's going on. Not just in the state of Ohio, but in all the states in the United States. Number 2, Carter versus Carter Coal Company. Number 2, that is Carter versus Carter Coal Company. This case prohibits legislative delegation in its most obnoxious form. When government delegates lawmaking authority to private economic interests, to private corporations, it is illegal. What I found in the state of Ohio, when 18 entity quarters of lobbying, that means there's 18 separate entity lobbyists. When 18 entity quarters of lobbying on a single bill shows the insurance industry functionally controls the legislative process, that's delegation of power to private corporations for their profit, which is unconstitutional. Right there. It's unconstitutional because the Supreme Court has found that in Carter versus Carter Coal Company, it is illegal when the government delegates lawmaking authority to private economic interests. It's already been decided. End of story. Number 3, it's easier. Yick Wo versus Hopkins. This landmark case prohibits arbitrary enforcement when the stated purpose of a law is satisfied, but enforcement continues anyway. I had insurance, financial responsibility was satisfied, but I was prosecuted anyway. That's arbitrary enforcement, and Yick Wo says that violates equal protection. Constitutional violation number 3. Number 4, Lawrence versus Texas. This case requires that laws serve a legitimate governmental interest, not just private preference or profit. When the citing officer in my case literally admitted on recorded call, and I have this audio, I'm tired of paying insurance, that proves the system serves extraction, not safety. I talk with law enforcement. Like I said, I was in law enforcement myself. Not all law enforcement is bad, but there's enough bad in it, and there's enough people in law enforcement that don't necessarily stand up for our constitutional rights at all. They don't at all. And that was one reason why I got out of law enforcement. And I was like, I'm not going to do this. Like, I see the constitutional violations. I see that, these oaths are not being held up, because if the constitutional oaths to protect our Constitution domestically and foreignly against all enemies is not being upheld, I'm not going to be a part of that. And I saw that, and I was like, I'm not going to do this. Number 5, sorry. Sands versus Roe and Shapiro versus Thompson. These cases protect the fundamental right to travel. Government cannot condition constitutional rights on commercial transaction. But that's exactly what these laws do. They say buy insurance from a private company or lose your ability to drive. Lose your ability to survive in the 21st century. Yes, you can do remote working, but ultimately the majority of the population still has to drive to get to work, to get groceries, to do the things that they need to do. It's not everybody, but the majority of the population still has to drive. And that is a constitutionally protected right. And you can see this through Supreme Court cases. Number six constitutional violation. The NFIB versus Sebelius. This is the Affordable Care Act case. Even the federal government, with its broad Commerce Clause powers, could barely uphold mandatory health insurance, and only by calling it a tax, not a criminal mandate. If the feds can't criminally mandate insurance purchases, except through taxation, how can Ohio do it with criminal penalties while insurance companies who lobbied for it profit directly? It's already been decided that can't happen. It just can't. The smoking gun. I had constitutional theory, but I needed evidence, and I found multiple smoking guns. Smoking gun number one. The Meigs County Court order. In my Meigs County case, the court issued an order that stated in writing, defendant to obtain license after 01/10/26. When this license suspension is up, when defendant obtains his new license and is able to pay for expired tags and show proof to the state will dismiss. Think about that. The prosecutor agreed in advance to dismiss once I jumped through the bureaucratic hoops. That proves this is not about public safety. It's about compliance with a system that enriches private corporations that are for profit. Smoking gun number two. Officer McGrew's admission. I have a 21-minute recorded conversation with Officer Joe McGrew. At the 6-minute mark, he says, "I'm tired of paying insurance." Because I had told him, I had told him the appeal that I was going through and that I have won. I told him about the Supreme Court cases and these violations of our constitutional rights. And he was like, you know what? I'm tired of paying insurance too. I'm tired of being forced. The officer himself said that he is tired of having to pay insurance himself to private corporations for profit that are enforced through the government. Now, in the state of Ohio, they actually have a fund that's set up for people to be compensated for injuries that they've sustained through car accidents. Now, my solution to it that I put on the record to the appeals court as a partial solution so that it could be on the record is that we have a 3-tiered system set up in the state of Ohio. The first tier is if you have enough money and assets, you're not required to have insurance at all. The second tier is basically for middle class, where if you want, you can decide to purchase your own insurance coverage, and be able to get as much coverage as you want. The third tier is for people who are poor and can't afford to pay for private insurance, and it would be a state-funded insurance coverage that would be like $200-300 a year for people who can't afford to pay insurance. And that would come from a pool of all those people who put money into it. There's plenty of states like Virginia, there's plenty of states like New Hampshire that actually don't only have mandatory car insurance requirements. They have other solutions for their people. The state of Virginia doesn't require needing insurance at all, but you have to pay $500 a year annually to basically as a tax to not have to buy private insurance companies car insurance. There's other solutions out there that we can do besides just having our legislatures pass laws because lobbyists from private corporations are saying, hey, here's some money, donations, pass these laws that benefit us when we have constitutional laws like I've described here that say that that's illegal. And I challenge this stuff in court. I challenge it, and I won. Smoking gun number 3. I had insurance. This one's simple but crucial. In the original Athens County case that started all this, I had valid automobile insurance throughout it. I satisfied the exact purpose these laws claim to serve, financial responsibility, but I was prosecuted anyway. That proves the real purpose isn't safety, it's revenue and corporate profit. Smoking gun number 4. The 4th District Court of Appeals in Ohio, when my first case was dismissed without prejudice, I appealed. I was like, no way. The 4th District couldn't rule on the merits because dismissal without prejudice isn't a final appealable order. It's a jurisdictional issue. But here's what the court did say on January 5th, 2026. The court finds there was reasonable grounds for this appeal. The appellate court validated my constitutional arguments had merit. They just couldn't rule because of the procedural posture. So the reason why Athens dismissed without prejudice is because they did not want me to be able to appeal. They were trying to avoid me being able to appeal their decision because they knew what they were doing was unconstitutional. And by dismissing without prejudice, even though I won the case, means that they could refile theoretically in the future. Basically harassment. That's why we have double jeopardy, to protect against those types of things. The legal strategy. Armed with this evidence and legal framework, I developed a specific strategy. Step 1. Comply with all requirements. I got my driver's permit, maintained insurance, paid registration, paid all fees, and served all suspensions. I eliminated any argument that I hadn't satisfied the stated governmental purpose. Step 2. File motions to dismiss with prejudice. In all 3 pending cases, I filed detailed motions arguing that dismissal with prejudice was warranted because I had satisfied all requirements. The 4th District Court of Appeals found reasonable grounds for my constitutional challenge. The prosecutor's willingness to dismiss upon compliance proved no public safety purpose. The constitutional violations, Marshall, Tumey, Yick Wo, Lawrence, Carter, Sands, and the NFIB barred prosecution. Dismissal without prejudice perpetuates the procedural manipulation the 4th District couldn't address. Step 3. Make the key argument. The most powerful point in my motions was this. When prosecutors agree to dismiss cases once defendants obtain a permanent license, they admit these prosecutions serve no public safety purpose, only bureaucratic compliance that supports corporate profit. This proves enforcement lacks the legitimate governmental interest required by Lawrence versus Texas. If it's really about safety, why dismiss the moment I check the boxes? Because it's about forcing compliance with a lobbying created system, not protecting anyone but corporations. Step 4. Connected to the lobbying evidence. I attached the Joint Legislative Ethics Committee reports, the cost analysis investigation. I showed the court exactly how much money changed hands and how the legislative process was captured by private interests. Step 5. Cite the pattern. I argued that dismissal without prejudice is exactly the procedural manipulation that insulates constitutional violations from appellate review. The state can charge you, but through the system, extract costs and compliance, then dismiss without prejudice before you can appeal, and do it all over again. That pattern, I argued, is itself a constitutional violation. The victories, and it worked. Athens case 2025 TRD 0604, dismissed with prejudice. Athens case 2025 TRD 06502, dismissed with prejudice. Meigs County case TRD 2501900, dismissed with prejudice. 3 cases, 2 counties, multiple judges, all dismissed with prejudice. That means these charges cannot be refiled, double jeopardy attaches, the courts agreed constitutional violations occurred, the system that created these prosecutions was found to be fundamentally flawed. This wasn't one sympathetic judge. This was multiple courts in different jurisdictions independently reaching the same conclusions about the constitutional violations in Ohio's insurance enforcement system. Think about what that means. Multiple judges looked at the evidence of the $7 million in lobbying, a 1,500 time underreporting, coordinated campaigns across 18 entity quarters, Officer McGrew's admission, the prosecutor's willingness to dismiss upon compliance, and the fact that I had insurance all along. And they agreed this violates fundamental constitutional principles. What this means for you. If you're facing similar charges in Ohio, here's what you need to know. Sorry. This legal framework is replicable. The constitutional principles I used earlier aren't unique to my case. They apply to anyone being prosecuted under these lobbying created enforcement mechanisms. The evidence is public record. The Joint Legislative Ethics Committee reports are available to anyone. The bills and their lobbying history are documented. You can compile the same evidence I did. The arguments have been validated. The 4th District said there was reasonable grounds. 3 trial courts dismissed with prejudice. This isn't a fringe theory. It's been tested and it worked. Here's what you should do. Get compliant first. Obtain your license, permit, get insurance, pay your fines, eliminate any argument that you haven't satisfied the stated purposes. Gather the evidence. Pull the Joint Legislative Ethics Committee reports for Ohio Insurance Institute, State Farm, Nationwide, Progressive, and the AAA entities. Document the bills they lobbied. Calculate the discrepancies. Research the cases. Read Marshall versus Jerrico, Tumey versus Ohio, Carter versus Carter Coal Company, Yick Wo versus Hopkins, Lawrence versus Texas, Sanzi versus Rowe, Shapiro versus Thompson, and the NFIB versus Sebelius. Understand how they apply. File a motion to dismiss with prejudice. Use the framework I've outlined. Argue that you've satisfied all requirements. Prosecutor's willingness to dismiss proves no public safety purpose. Constitutional violations warrant dismissal with prejudice. The lobbying evidence shows government serving private interests. Attach the evidence. Include the Joint Legislative Ethics Committee reports, the lobbying summaries. Include articles from investigative journalists' findings, court orders showing prosecutors agree to dismiss, and any other evidence of the systemic issues. Make the key arguments. If these were really about public safety, why does the state agree to dismiss the moment I comply with bureaucratic requirements? Because the system serves corporate profit, not legitimate government interests. And I'm going to show you these things. Now, this packet right here This packet right here, the Master's Motions packet, I filed this in the Athens County, Ohio clerk's office, and it basically contains all the motions and exhibits that are within this packet, motions and evidence that I submitted to the court. It's probably easier if I just do this for you. These are all the exhibits. These are all the motions and demands I made to the court that you can see right here. Now this was one case in Athens County, Ohio, of the motions and exhibits and demands. This is all legitimate. Now in this, I'm going to show you the actual hardcore evidence from the state of Ohio's own documents through the Freedom of Information Act. This is right here. This right here, is the lobbying cost analysis insurance industry Ohio campaign from 2018 to 2025. Research that I did, investigative research. Documented lobbyist employment entity. The Ohio Insurance Institute had 4 to 5 lobbyists active for 7 years. State Farm had 3 to 4 lobbyists for 7 years. Nationwide had 4 to 7 for 7 years. Progressive had between 1 to 2 for 7 years. AAA had 5 different lobbying entities in the state of Ohio. And out of those 5 different entities, they had between 2 to 3 each for 5 to 7 years. So total, in just the 6 largest car insurance companies in the state of Ohio, between 15 to 20 lobbyists through 7 years from 2018 to 2025 were employed. But yet they said they only spent $4,666 between all these companies in 7 years, which is impossible, because when you look at the cost estimates, lobbyist compensation industry standard, contracted lobbyists are paid $10,000 to $25,000 per month, which is $120,000 to $300,000 annually per lobbyist. In-house lobbyist salaries are between $100,000 to $200,000 annually. Conservative averages is about $150,000 per lobbyist annually. 15 lobbyists times 1,500 times 7 years is 15,750,000. But they only reported that they spent $4,666, which the national averages show that that's not, that is like, that is just so far off. It is fraudulent. It's fraudulent. And I was going, I was demanding a jury trial to present all this evidence that I have from Freedom of Information Act, as well as documentation from the averages nationwide of what it costs to run a lobbying scheme, basically. Additional cost: research policy staff between $500,000 to $1 million annually. Legislative tracking services between $50,000 to $100,000 annually. Campaign contributions, indirect, $1 million plus annually. Events, entertainment, and travel between $200,000 and $500,000 annually. Administrative overhead between $300,000 to $500,000 annually. Total estimated annual operations between $2 to $3 million. 7 years to operate something like this for 7 years between all of these entities, totaled between $14 million to $21 million. But they said that they only spent $4,666 on the Joint Legislative Ethics Committee reports in those 7 years to the state of Ohio. Why am I 7 million? Why am I 7 million? Why my 7 million is conservative. Reported from these corporations, they only spent $4,666 over 7 years. Realistic minimum between 7 million to 10 million. Probable and actual cost between 14 million to 21 million. Evidence supporting higher figures: 18 entity quarters on single bill. Senate Bill 37 equals intensive campaigning. Multiple concurrent bills: Senate Bill 37, Senate Bill 152, House Bill 283, House Bill 106, House Bill 158, House Bill 336. 7 years sustained operations. 15 to 20 professional lobbyists employed continuously. 7 million figure represents approximately 50% of the probable actual expenditures. Conclusion: insurance industry spent minimum 7 to 10 million lobbying Ohio legislators between 2018 to 2025, while they reported 4,666 to the Joint Legislative Ethics Committee, reporting a 1,500 to 2,000% or times underreporting of actual expenditures. Total fraud, in my opinion. If they didn't dismiss it, I was presenting all this to the jury. Here is the Joint Legislative Ethics Committee lobbying report summary between 2018 and 2025. Attached defendant's response to discovery, the case number, summary of key findings. Right here, analysis of the Joint Legislative Ethics Committee lobbying reports reveal coordinated insurance industry campaign to create and maintain mandatory insurance enforcement mechanism. This goes to the Senate Bill 37, coordination, driver's license, suspension, financial responsibility, 18 entity quarters of coordinated lobbying, the entities, how many quarters, the period in which they lobbied them, pattern, 4 separate AAA entities lobbying identical bill in identical quarters demonstrates coordination, not independent advocacy. Additional enforcement bills lobbied. Senate Bill 152, after penalties, altered penalties for failing to maintain insurance, and that was in 2019. And this shows all the quarters. All the quarters. All the different bills that they lobbied for. The expenditure underreporting analysis. The expenditure underreporting analysis of what actually was spent based on the national averages to run lobbying campaign schemes. And as you can see, a minimum of 7 million, you know, and in 7 years, at least 7 million. So you're talking at least a minimum of $1 million. And they're reporting that they only spent $4,666 in 7 years. Is just, it shows that they think that we're all fucking idiots. I mean, it shows that they think we're stupid. Is basically what they're doing. They're just like, these people will never look at anything. They're never going to give a crap about looking at anything. Well, I like doing investigative research. I like finding the truth. I like our constitutional rights. So I'm going to fight for our rights and for everybody, you know. And that's what we all should be doing, you know, the best that we can, whether it's going out and protesting, whether it's going and representing yourself in court, whether it's going and sharing information for other people, you know, it's our right to do that. The constitutional significance. Coordination proves insurance industry created enforcement mechanism requiring purchase of their products through coordinated legislative campaign while concealing true expenditures from ethics oversight. Direct financial interests. Some companies that lobbied for mandatory insurance laws benefit from government enforcement, denying driving privileges for non-compliance. Regulatory capture indicators. 1,500 time expenditure unreporting. Coordinated multi-entity lobbying on single bills. Strategy. No activity reporting while employing multiple lobbyists. Enforcement laws directly benefiting these lobbying entities. And I have the full 112-page Joint Legislative Ethics Committee report completion available upon request. So if anybody wants to see them, I have those all saved. I have all that I went through and documented that I can send you. Now, all of these are separate cases. Like, all of these are separate cases. This is a separate case that I had in Lancaster, Ohio. This is a separate case that I had in Athens that I won. This right here is all my documentation for my appeals to the 4th District Court in Ohio, where I had the panel of 3 judges in the 4th District Appellate Court confirm my constitutional arguments that were being violated. They confirmed that I was that I was right, and the lower trial courts acknowledged that once the appeals judges confirmed my argument, and I had submitted that documentation to the trial courts through motions motion for dismissal with prejudice because they violated my constitution. They violated all of our constitutional rights. This is my argument, and it was confirmed. And I have all of it documented for everybody to see. This is for Meigs County. This was all Meigs County case right here. So I went in there and I showed them through the Constitution that they were violating all of our rights, and that corporations are, the corporate capture of our state and local governments, and it was confirmed. And I think it's important that we fight for our rights in whatever capacity that you can do it. Whether it's representing yourself pro se in court and demanding a jury trial and showing everybody in the jury, who are people like me and you, hey, they're violating our rights. They're violating all of our rights, Like, and you gotta stand up for it. And we gotta back each other. And I'm glad I was able to win those cases and put all that information and data on record for other people to use, to continue this fight against corporations who are violating all of our rights. And I just wanted to share all that with you guys. And I hope you guys have a good day. Thanks for watching.